Good afternoon, everyone, and welcome. A belated Eid Mubarak to those who celebrated the festive event. I'm Nomti Nisi, I'm SAMED's Communication, Marketing and Events Manager, and thank you for joining us in today's session. Before we dive into the meat of today, I would just like us to just do a few housekeeping rules. The session is being recorded, so by participating, you consent to the recording. Please keep in mind SAMED's values, which are displayed on the screen. And also when engaging with speakers. A quick reminder about our conflict of interest competition law. We have outlined some do's and don'ts. Please have a look at them and familiarize yourself with them. We do encourage questions, lots and lots of questions. This is for your benefit and for your clarity. So feel free to drop them in the chat or raise your hand and I'll give you permissions to use your mic to be able to articulate yourself properly. Otherwise, it's going to be a very good time today. Also, if there's any other questions that may arise post this event, feel free to send me an email and I'll make sure that I engage the speakers. And also let me know what future forums would you like to have. This is also a great way for you to know that we really do listen to your needs. We've got a great lineup today and it's quite important. So I appreciate your time that you've set aside. We will definitely kick off with our first speakers. You'll see that our areas of discussion are quite direct and straight to the point. So the first section will have co-presenters. We've got Elsa B. Klink, who is the Managing Director of Klink & Samuels, a consultancy specializing in health law, policy and ethics. With over 24 years in health sector, she advises professionals, suppliers, and facilities facilitates as well on legal matters, regulatory matters. And she's formerly a senior lecturer in constitutional law. She also worked on human rights, land reform, and social security at the Free State Center for Human Rights Studies. Elsa B has published and spoken and has been spoken about widely, especially around the health laws, the ethics and human rights. And then she's also got a degree in German. So I'm hoping today you will be presenting in English, Elsa B, and as well as a degree in applied psychology. And her co-star was going to be Heather Irvine. She's a partner at Bowman's. She specializes in complex mergers and competition law proceedings across Africa. She has extensive experience advising on significant transactions. Heather also counsels clients on market inquiries and behavioral investigations. So you are definitely in safe hands because she also recognizes, she's also recognized for her expertise in navigating the dynamic regulatory environment affecting tech companies. Ladies, it is indeed over to you. Please go ahead and let me not hold you back any further.
Thanks so much, Nomti. I'm always thinking you sound like you must be presenting on this amazing program. Like a Leanne Manas or somebody. So,
I'm sure the presentation will have its forms of like edge of the seat kind of moments, but I trust you to lead us into a good and informative session. Go for it.
Good. You can go to the next slide, or can I move the slides? Must I move? Can you move? Okay. All right. So this is why I'm calling this a spaghetti western. The block exemption is something that is flowing from what happened many years back when the Medical Association, the BHF, everybody was fined for collusion. And they were fined because the schemes on the one hand and the doctors and the OTs and whoever else on the other hand were each agreeing on what the fees and tariffs would be, medical schemes what they want to reimburse, and doctors and healthcare providers what they want to charge. They then went into a negotiation, and that was that photograph there, and they were negotiating and they never reached an agreement, and then they published their own so-called tariff guide. results. Now, what this block exemption does is it now says that because we kind of want to permit collusion now, so we're exempting people from this prohibition on collusion, and they're proposing a very specific structure. And that structure is right in the middle. It's called the Multilateral Negotiation Forum. It sounds like one of these LOL or XOXO type of things that people use and the teenagers and so on use. And perhaps I'm just old-fashioned, but yeah, it is a multilateral negotiation forum. Now, that is something that the Health Market Inquiry recommended, but not in this format. And Heather will go a bit into those details. But what this structure will do is it will negotiate tariffs and codes, including medical device codes. And this is where it is important to just bear that in mind. What will they negotiate? They will also negotiate outcomes, and they will negotiate formularies and treatment protocols or treatment guidelines. So this middle entity will have a massive task in negotiating things. The important thing is, whereas normally if we get exemption from collusion, you'll have, like we had in the past, the Medical Association, for example, and the BHF, they would negotiate with each other. This structure says, no, we're not going to allow you to directly negotiate. You're going to nominate people, and the minister will appoint negotiators. And this time round, the negotiators would come not only from the two parties, the people that charge fees and the people that pay fees, but also include representatives from patients, that's the pink, and government. That is that funny darkish red color. So people will make nominations, and the minister will appoint the entity that will negotiate. So just in terms of normal negotiation protocol, this is a bit strange, because how will an organization mandate somebody to negotiate on its behalf if it's not their person that is sitting at the negotiation table? So I've got my question mark as to whether this is really, whether the N belongs in that abbreviation, whether it's actually a negotiation forum or if it is something else. Then the document also says that data must be submitted to the Council for Medical Schemes relating to what will be negotiated about. So for healthcare providers, it would in all likelihood be practice cost studies, and for medical schemes, it will be claims data. And they actually say they want claims data. Now, that will be at the Council for Medical Schemes. Now, if there is disputes about the data, or if there's uncertainty as to the validity of the data, that block right at the top, the TGB, the Tariff Governing Board, is the organization that will, or the entity that's appointed by the National Department of Health and the Council for Medical Schemes to verify the data, but also to be a body that will make a final call if no agreement is reached at the multilateral negotiation forum. So it's basically a reviewer and appeals body that's been created. Then you'll see there's two other pieces in the bottom corners of the slide: health technology assessment and coding. And here the document says that the multilateral negotiation forum will work with the Health Technology Assessment Ministerial Advisory Committee and the outcome of their work, and the Ministerial Advisory Committee on Coding. And these are two bodies that has been kind of re-established now in the NHI times. And they also, the document also says that we can't, if we don't have official outcomes on HTA, the the best available information will be considered. But it clearly links HTA, which is about you, the medical devices sector, and coding, which is also about you, into this negotiation process. Next slide. So this is just the list of the things that will be negotiated, tariffs, and there they say they'll use a price cost methodology. Now, price cost is something that's used, and Heather would know and can explain a bit more, in excessive pricing cases. But it seems to simply say that we want people to be reimbursed on what it costs them to render a service plus a little bit. And I think that's where, what does it cost you to bring a piece of technology into the country, for example, and what would be a reasonable markup on that. Then codes, then quality measurements. And here I think they get a bit confused between what outcomes is versus quality measurements. And I'm also not sure why that even features in these negotiations, because it's a scientific separate activity that the Office of Health Standards Compliance does. The same, they talk about medicines formularies and then treatment protocols and guidelines, which would then be recommended to the National Department of Health. And then one also thinks, why? Because medical schemes do their own thing in terms of the Medical Schemes Act in this regard, and they're entitled to do that. And there is an essential medicines list process, and they're busy with an essential equipment list process. So how would this, that's basically about medical schemes in the private sector, feed into the National Department of Health, and what will the National Department of Health then do with that in terms of this tariff negotiation process? Next slide. So what they clearly say is excluded is medicine single exit price and NAPI codes. But that now means that the device codes are included. And that includes then device codes such as higher fee that a doctor may charge, or device administration costs, or the consumables are obvious. The minister, when he announced this at his press conference, went all out against the very bad companies that sell ultrasound machines to doctors, and how they want the doctors to just overservice, and all of these women are just asking to get the sex of their babies. And you know, he knows, and he's worked in there, and I know he knows what the device companies are doing. So he basically made allegations of overservicing and kind of justified this block exemption with reference to allegations of overservicing, or inappropriate servicing. The other exclusion is hospitals, and all health facilities are excluded. Now, this is strange, because then if a healthcare professional is employed by a hospital, they won't be affected by this block exemption and the outcomes of the tariff negotiations. But if they're not, they will be affected by it. And this also, how will we deal with global fees? Because especially those of you in orthopedics and in cardiology will know there's TAVI global fees, there's arthroplasty global fees. So, and that goes through the hospital often. The other thing is then, if a medical device is used or billed by the hospital and not by the doctor, it also won't be affected by this. So it raises these discrepancies. That's a bit odd. Next slide. That's over to Heather then.
Thanks, Elsie, and good afternoon, everybody. That slide is definitely the most coherent explanation I've seen of what this exemption tries to do. And as you can see, it's quite complicated. So what do we think about this proposal from a kind of purely competition perspective? Well, I think there are two sort of big picture grounds for objecting to this proposal. One is that I don't think this is a lawful exercise of the minister's power under Section 10 of the Competition Act, which is really limited, right? It says that the minister is allowed to allow certain firms to do certain things, reach agreements or understandings,
as long as they promote the objectives of the Competition Act. And secondly, obviously, one would not want to see an exemption from the Competition Act, which would actually lessen competition or distort competition in South African markets if there weren't very good reasons for allowing that to happen. And fundamentally, we just don't think that's the case here. Thanks. Next slide. So why do I say that I think it's not a lawful exercise of the minister's powers? The block exemption mechanism is really intended to allow firms to get together and do things like agree on prices or divide up markets if they can show that that exemption is required. In other words, there isn't any other way to do it, and it's necessary in order to give effect to the purposes of the Competition Act. And if you open up your Competition Act, you'll see there's a whole long list of them. But nowhere in that list does it say anything about paving the way for the NHI, fixing deficiencies in the healthcare legislation that currently exist, sorting out dysfunction in existing regulatory bodies. The Competition Act doesn't talk about any of those things. And the draft block exemption notice doesn't closely tie the proposal to any specific objective in the Competition Act. Fundamentally, regulations under the Competition Act, which are made by the DTIC minister, can't simply be applied to achieve government's general purposes or policy goals. And here, it was quite clear from the presentation, and you can see it in the memorandum. This thing is intended to facilitate mechanisms which will then become the testing ground for the NHI. And the minister said as much in his presentation. So you can't take a statutory power that's granted for one purpose and apply it for a different purpose. That's a very settled principle of administrative and constitutional law. And as I said, the DTIC minister can't go around trying to fix laws that don't work or regulations that are unsuitable or other regulators who should be doing their jobs, but they're not, through making regulations under the Competition Act. And I think these regulations, in a sense, the proposal that we need a block exemption to do the things that Elsie is talking about, to set tariffs, to formulate codes, or to set standards or metrics or treatment protocols. These are currently things that are regulated to some extent, and maybe they could be regulated better, or we need further regulation in the form of an act of parliament. But that's something which needs to be done properly. There has to be a legislative process. If it's a regulator not doing their job, they should be taken to task by the responsible minister. They should be capacitated and resourced to do their job. But you can't just take a shortcut by using the Competition Act to fix all these problems. Thanks, Monty. So as Elsie said, I think there is a big problem here, which is the suggestion is that these agreements on tariffs and codes and protocols will be reached by the MLNF. The members of that body are nominated by the Director General of Health, or failing some sort of agreement, they'll be imposed by the TGB. But this is not fundamentally what an exemption is required to do under the Competition Act. The Competition Act says it must exempt a category of agreements or practices. So in other words, whatever the practice is, if it's price fixing, if it's dividing up markets, if it's allowing collusion on tenders, it should be allowed by anybody who is doing it for the purpose that the exemption relates to. You can't say it will only be an exemption available to some firms who happen to be chosen by the Director General or imposed by the TGB. I don't think you can carve an exemption to that narrow extent. If you decide we should allow bargaining on tariffs to happen collectively, then it should apply to everybody. And if you don't apply it to everybody, I think it's not consistent with what the Competition Act contemplates. Thanks. So, importantly, I think there's a big picture point here, which is that what they are trying to do here is really well beyond the scope of what the Competition Act is intended to do. Fundamentally, the Competition Act is a piece of legislation that is supposed to preserve competition in markets, and it's supposed to lower barriers to entry and facilitate participation by small competitors or historically disadvantaged persons in South African markets. This is at the heart of what it's intended to do. It's really got nothing to do with what the ultimate aim of setting codes, having quality measurements or metrics, or deciding on medicine formularies or protocols for treatment. Those things are all really a professional activity, right? They are absolutely focused on patient welfare and really fall way outside the Competition Commission's job in terms of protecting competition in South African markets. So the tool that's being used here is just not the right tool. And I think importantly, the suggestion that there would be agreements reached under the auspices of this MLNF or determined by the TGB is fundamentally flawed, because obviously only certain funders, the ones that are lucky enough to be chosen by the DG of Health, and certain HTPs, once again, the people who are lucky enough to make it into this MLNF, only they would make decisions on these really critical things. What should the code for this be? How many codes should there be? You know, what sorts of devices should apply under each code? That, you know, a small segment of the medical value chain that is involved in treating a patient, for example, a hip replacement or a piece of cardiothoracic equipment being implanted. Only some of the people are around the table when these decisions are taken. At the end of the day, very important stakeholders, the people that manufacture the device and the hospital that hosts the procedure, are not even present in that forum when that decision is reached. Thanks. Next slide. So there, I think, yeah, next one, sorry. So that's the sort of big picture point around lawfulness. I don't think the minister of the DTRC can actually use his powers under the Competition Act to do this for various reasons I've discussed. There's a second kind of big picture reason to object to this exemption, and that is that exemptions to the Competition Act are supposed to be temporary. They do allow things that are generally anti-competitive to happen, but there has to be a good reason for that. The exemption has to yield pro-competitive gains, technological gains, or otherwise be good for efficiency in a way that's not achievable absent some impact on competition. Now, that is not fundamentally what the result from a competition perspective would be if we see this exemption coming into effect. So currently, the funders have to compete with one another on the nature and the level of the benefits that they offer to patients. However, if the MLF can now decide things like tariffs around the table with some funders gathered there, this obviously deprives patients of the competition, the arms race that's going on between the funders all day, every day, that they will then just have to live with whatever decisions are coming out of these bodies. And it's quite clear, as Elsabe said, that the main driver when those firms are sitting around the table is going to be price. In other words, how can we get discounts for bulk purchases rather than choosing the product or quality of service which is best for the patients? And this is quite clear, as Elsabe said, from the fact that the way in which the TGB must adjudicate whether or not the tariff that's agreed in the MLNF is reasonable or not is only done with reference to price cost. So there's no mention whatsoever of quality, innovation. There's no kind of contemplation of whether it meets international best practice or South African standards or anything of the kind. So the primary purpose of allowing this negotiation to happen around the table is to drive costs down. And that's also clear from the way in which it was presented by the minister. Thanks. So, you know, it seems to me that the primary purpose is to allow those few firms who manage to get into the negotiating room to decide on tariffs that are as low as possible, as close to cost as possible. But importantly, the results of those decisions, I think, are likely to flow outside of the room. So as soon as those funders and HCPs have agreed on a tariff for a particular product or service, that will become the market standard. I think it would be very difficult for those suppliers outside of the room to say, no, we want to supply our product. They've decided on 100 Rand, but we want to supply our product for 120 Rand because it's just much better. It does things that that product can't do. I think the likely answer would then be from the other funders, even the ones who didn't gather around that table, no, we think 100 is better. So it's likely to have price fixing effects across the whole industry and not only inside the group of people who actually reach the agreements. And of course, this confers a form of market power. Those companies who get into the bargaining room are going to be in an incredibly powerful position versus their competitors that are outside and versus the people that they are funding, because fundamentally, they are going to be taking decisions alongside a small group of HCPs, which get transmuted across the whole industry. And there's very little prospect that that decision can be shifted because the people on the outside can't bargain collectively. So it's not like the device suppliers can get together and go, okay, but none of us will supply at that price. That would be anti-competitive, and there's no exemption for them. So it does create a very unequal field for bargaining and exacerbate the problem that we're already seeing in the industry, where the decisions made by one or two funders on price are already having distorting effects, I think. Thanks. I'm happy to take any questions alongside Elsabe when they come, Nomti. Thanks very much.
Super, thank you for that. The floor is open. I received some questions via email as well, so I'll also post those in the interim while we wait for some people to also raise their hands. Amanda, you can go ahead and utilize your mic.
Thank you, Nomti. Good afternoon, everybody. There are two things. Number one, the nature of the legislation. I think we tend to think that if we stick a plaster on things, it reminds me of wound care. All we have to do is stick a plaster on it and it will fix the problem. And in the meanwhile, limbs are dropping off. So I'm smiling to myself. But this whole notion and the interconnectedness of testing something in a primarily private setting, first and foremost, but then with its impact on NHI in the future, that it might start with the health funders from a private perspective, but then lessons are going to be learned that potentially can fall into NHI in parallel as well. And I think this is why it's perilous. But I think most of all, it's this notion that you can fix things by just putting a plaster over them. And rather than getting in there and finding out what the root cause is of the actual problem. And a lot of our legislation and policy needs a relook in terms of what it's focused on and how we need to get there. It's interesting. It's a very interesting discussion.
Yeah, agreed. I mean, the suggestion that you would exempt a small group of firms from activity that the Competition Act says is anti-competitive, and in fact, the Commission accepted when the BHF put in an application to be exempted to do something a little bit like this. The Commission didn't grant that application and said, we don't think this kind of collective bargaining by the BHF members would serve the purposes of the Competition Act. The thought that you would now allow it on a kind of even grander and more complicated scale is really peculiar to me. And I agree with you. I don't fundamentally think that this is going to fix the problems that it's trying to fix. And the draft says all of these things, bargaining on tariffs, codes, metrics and protocols will happen to the extent that the there aren't codes that are developed, or the HTAs haven't been done, or there haven't been metrics put in place. And that kind of begs the question, why is it that we are not just, properly regulating those things in a transparent way so that everybody who has some sort of interest is able to make submissions, and then an independent regulator like NERSA or ICASA in the telecom space then has to make a decision. NERSA does this all the time. What price must we pay Eskom for electricity? Everyone gets a chance to make their representations, and then the price gets set. This seems to be, very, very far away from that sort of generally accepted regulatory process.
And I do think as well, it's possible to stratify the tariffs. If you look at, for example, at the UK, I know it's the government sector with NHS, but the UK drug tariff, but then again, Australia, they do have fixed tariff pricing. However, depending on the quality of your product, it can sit at an upper level, a mid-level, or a lower level, depending on the data that you can actually supply for it. So it's not a single price, if I'm making sense. It's actually relative to the quality of the product.
No, understood. And I think that's an excellent point. I don't know why we would want to reinvent the wheel. There must be several models available globally that could be drawn on and implemented. Whereas I've not been able to find any equivalent under any competition legislation that works like this block exemption.
Thanks for that, Heather. I think it definitely answers one of the questions that also came through around there being any international precedents or models that influence the drafting of this exemption. So if you haven't been able to find anything, it begs that question, why? But there's another question that came through. What timeline are we looking at for the finalization or the adoption? And how can SAMED members meaningfully engage in this process before it's finalized? I think it definitely ties into Tanya's questions in the chat. Do you advise that members submit their own individual submissions? How would they go about this, and to whom do they submit? Do they still have to ask for an extension?
So SAMED, of course, is going to provide a submission. LCB and I are working on that, and it will be a sort of a legal submission combined with a document that highlights all these practical challenges, focusing on the existing healthcare legislation and regulations. So that is already in process. It's going to be a SAMED document. There's no reason why individual members should not submit their own comments. Anyone who wants to submit a comment should write to the minister's office. There is an address provided in that Government Gazette notice. I'm happy to share that after the meeting, or we'll pop it in the chat box. And this is a public comment process, so there's no requirement that you make any of the high level legal points, and some of them are quite complicated. Even sort of examples of how this would not work or would lead to perverse outcomes, I think would be very helpful. And, at the end of the day, the DTRC minister is a new minister. He has succeeded Minister Patel. This is the first time that he's being asked to exercise his power under this section of the Act. And I think it would be important for a large number of people to let him know if you don't think that this is a good idea. And I think he will be very careful, given that he's fairly new in his seat, about implementing something which a lot of people are writing and saying is a problem, and giving him some insight into why they're saying it. So anyone can submit an objection. It can literally just be in the form of a letter on letterhead from your company. You don't necessarily need a lawyer. If anybody wants some help with this, LCB and I would be happy to oblige. There's no reason why we can't help with anybody who wants their own submission to focus on specific things. LCB and I are always happy to work together. LCB, we've done so for a very long time, and very happily so. So yeah, we help with that. The only thing I would say is there is that you'll see in the Gazette notice, the date for objections, I think, has now passed, but the minister has been giving extensions. So I think the 18th of May is now the deadline that SARMED has obtained. If you just write and say, we are still preparing our submissions and can we have until mid-May, I'm quite sure that you would get the same email back again. And then when you send your letter, it will count towards the objections received. Do you agree, Elsie?
Yeah, definitely. And they do count numbers of submissions received. So how weird that is, SARMED's view will count for one view, although it's actually way more than one view. So I always like this thing if you kind of are supportive and you can say, I agree with my trade association, but I'm now able to share examples that I can't share in the trade association setting, for example. So one can actually beef up by doing that. So I've always, and you guys know, I've always liked that if individual companies also, it also shows an engagement, and it's sometimes very good to up your company's profile at the DTIC. So there's another angle to that as well.
Thanks, ladies. I'm interested, are there any limitations on the types of medtech products or services that can be included in the tariff discussions under this exemption?
No, they only exempt actually the medicines pricing. So the single exit price is exempted, but medicines in itself is not exempted because formularies are included. So even for them, it's just the single exit price. But if you don't get onto a formulary, and that somebody said quite clearly from the Medicines Pricing Committee, is that the idea is that you will lower your single exit price in order to get onto the formulary. So they want to use that collective bargaining process to even force what we know currently as regulated prices, to force those down. But they haven't excluded anything. So if you have capex that's bought by a practice, for example, but they charge a higher fee, a rental fee, and there's codes on that, you will be implicated by that. If the consumables are charged by the practice, then one will be implicated by that. Conversely, if it's charged by the hospital, you will not be implicated by it. But the minister was very clear in his example that he thinks that doctors are abusing ultrasound. I don't know why he picked ultrasound. Why do you pick on pregnant women? I mean, that's politically so unwise to do. So, but it was clear that those codes, and this is where I think nice examples can also come from individual companies. Those of the members who've been involved in global fees would also be able to give quite nice examples of what's happening and how does that work. And how would that now work if the global fee is paid in TAVI, for example? Sometimes they pay the global fee to the anaesthetist, and the anaesthetist then divvies it out to the cardiologist and the cath lab. But in other cases, they get paid to the hospital. And now you have a similar situation that's regulated differently. And I think that's where individual submissions could also make quite nice contributions.
Wow.
No, I absolutely agree with that. So at the end of the day, this document says, we think that this body, which includes some funders and some HCPs, will be able to reach agreements on healthcare services tariffs, but it doesn't say what services, so it could be any service as I read it. Can also determine standardized diagnosis, procedure, medical device, and treatment codes. So codes for any of those things can be determined by them. And of course, coding is not just an admin activity, right? The decisions about what is inside the code or outside the code fundamentally go to what the patient gets or needs, and importantly, what the price for the product is. So that's obviously very extensive. Anything that falls within that big catch-all can be done by this body. And then lastly, as Elsie said, treatment protocols or guidelines. So, I mean, that to me suggests that they could decide what goes into a standard op, for example, what sorts of a product should be used or shouldn't be used, anything to do with anything in the value chain, whether it's a device that's implanted or any of the equipment that's used in the operating theatre, any of the kinds of products that are used alongside that to support the operation that's happening or the post-operative care. It all seems to fall within the bucket of what they can reach agreements on.
If it is adopted and goes ahead,
Correct.
does this framework create space for engaging with reimbursement decisions or funding mechanisms for medtech under the NHI?
No, because in a sense, Nomti, I think this will precede the NHI. So this is almost like a stopgap. It's meant to help us get into the NHI world. And if it happens, I think the way that it works or doesn't work will probably shape some of what eventually ends up happening in the NHI world if we ever get into that world.
Interesting. Okay.
Can I add to that? So what was said in a so-called CUPS meeting, that contracting units for primary healthcare that the NHI Act refers to. So phase 1 of the NHI must be completed by year end 2026, which is March 2027. And in one of those meetings, it was said that the Department of Health needs to cap fees before they can start with this first phase of contracting, which is contracting for so-called vulnerable groups. And then so there was somebody there that said, what do you mean by capping? Are these block exemption things? And they were told, yes, that's exactly that. So it is, and it was explained that that's why government is in that mix, so that there could be a depressing of those prices, whatever it would be. It's not clear what exactly of vulnerable groups we're going to contract. And does that now include the pregnant women, for example?
Yeah.
But it could then affect a whole range of people. So because if it is pregnancy, for example, then the minister and his whole issue with ultrasound is up for grabs sooner rather than later. That's also why we'll talk about the regs, the draft NHI regs, because they need to have the entity set up that can contract with providers under this phase 1 of the NHI Act. So I think may see this sooner rather than later.
My goodness. So you think there could be unintended gray areas or consequences as well, I think, in areas of competition law or even public procurement? Are you there? There you go.
Yes, I am.
Oh, yeah.
No, definitely. I think so. So I think it was made clear in that meeting that this block exemption is actually not. It's actually not about the private sector. It's to get prices that would be contractable given the public sector's lack of money in the next year, but the obligation that they took on themselves to actually implement and have phase 1. Remember that phase 1 ends in 2026.
Yeah.
So we're not far from there.
Yeah. Thanks for that, Elspie and Heather. Amanda, your hands up.
Thanks, Numti. Yes, Elspie, I can feel it in my bones, as it were. We had a IPASA, I want to call them PIASA, but that was the old name, IPASA meeting with the EU and the Department of Health this morning that was quite interesting. And it was very much coming from an innovation perspective, but at the same time, Amban Pillay was there and Mark Bletcher was there as well. And they kept stressing how under stress the budget is. So how much as our industry perception of innovation might be up there in the clouds, they're looking more at reality in terms of it's not just calling something innovative, it's that it truly, truly means something. And the lady from IPASA was busy saying, oh no, if your medicine's 20 years old, it can't possibly be innovative. I would have argued that if you change the indication or you tweak it a little bit, actually it could become innovative again in terms of that. And that ultimately it's value for money, it's genuine value for money that we're going to have to be able to prove, whether it's medicines, diagnostics, or medical devices. And that is possibly our best defense. But Heather, I added it in the questions. There might be other industries that if this change happened in healthcare and then it was somehow transferred to another industry, would have an equally dire impact. And it's worth having a think about that there might be strength in numbers as well, that if there are other industries, that if this kind of thinking were to be adopted and permitted, would equally have an impact, a negative impact on competition. It's worth, maybe BUSA might be interested in doing something.
Thank you, Amanda. Thank you. I'm not seeing any further questions in the chat, nor do I see any hands up. I think it is quite pertinent, because you've touched on it, LCB, for us to maybe do a dive into the NHI regulations. Heather, you've done a sterling job. Thank you so much for the section. And of course, if members still want to reach out and ask further questions, our inboxes are open. And we will definitely provide that. I see Sarah is asking a question. There are questions in the QA section. Would you mind elaborating, Sarah?
I can see them. Nomti, I don't know if you can see them. There's one by Avanti, and then there is another question by Amanda's asked a question, and then two by Sarah.
Please go ahead. I cannot see. I think it's because I'm just presenting. Yes.
Okay, great.
Thank you.
So Avanti is asking, within the proposed structure, can you describe the best case scenario for MedTech with a view for SAMED to advocate for that? And I had a very typical LCB answer. I don't think there's a best case in this. This just can't work.
The best case scenario is that we can spook the DTRC minister into thinking that this is all very complicated and impossible to implement, and he doesn't pass these regulations.
Exactly.
Any version of this block exemption is going to be a disaster for MedTech, because you will not be sitting around the table when the funders and HCPs take decisions on tariffs. That's I think the short answer.
Then I see Sarah's asking, what will be, or can you confirm the chosen medical device IVD PMB formulary? Any insights on that? How or who will define this? So they just talk about these treatment guidelines, and they only talk about medicines formularies, which also says to me perhaps they're not clear on how this works in reality. So and I think in particular for diagnostics, for in vitro diagnostics, this is because your products in IVDs are going into the pathology labs mostly, or then at point of care with point of care devices, which then again creates this discrepancy. So I know in the NHI they're working on an essential equipment list. And I think that's something tangible that one can focus on. But I don't know how they're going to, if they envisage a list like they had in that primary care PMB drafts, where they had a list of diagnostic tests that's included in an envisaged primary care PMB. I'm not sure if that would form part of this, or currently it's just so widely formulated that it could include everything. And of course, this applies to PMBs and non-PMBs. They're saying these tariffs will apply not only to PMBs, but also to non-PMBs. So it's basically everything. So, yeah. Then Sarah, you're also saying we've heard that certain entities have received an extension. Yes, and I have no doubt, like Heather has said, I have no doubt that people will get extensions as well. There's no way that they can give extensions to some people and not to others. So even if one writes to them now, I mean, we didn't even have, it went later when people applied, it was barely opened, the email, and then they got the thing back and say the dates were just different. People got between 14 and 18 May as the extended date. But yeah, go for it. I think one should.
Super. Thank you for facilitating those questions. Tanya.
Hi, Elsie and Heather. So worst case scenario, we make our submission and our concerns are not heard and they forge ahead. What do we do then? And also, should we be requesting sort of an in-person audience with them to put our perspectives forward? Because and also, do you have any insight into other stakeholders that are impacted by this and what they're planning to submit, if you are able to share or not? So I just kind of want to get a sense, are there any stakeholders that we're aligned with or that we seem aligned with that we might actually want to engage and have a united front? Yeah.
Yeah, and there I can immediately say to you, PTG, they should have reached out to you already. So that's the pharmaceutical task group, because you have a lot of things in common. Of course, they're mostly price regulated, but they are as concerned as you are, and they want to make sure that there's alignment in terms of the supplier industry, that will all be kind of indirectly affected and never have a seat at the table. So I just know that they've been busy. The chairperson is Stavros and the deputy chairperson is Rulani from Pfizer. So if you need to make contact with them, Tanya, we can do so. The doctor groups are just saying, no way. They kind of all submitting, their submissions are like in the strongest possible terms. They all, whether it doesn't matter which professional society it is, particularly from the doctor side, are saying, we're not going down this route again, and we're not going down the NHI route, where we kept on making comments, kept on being constructive, kept on trying, and we're in the end just fobbed off. So that whole UAC group are united in saying, no way, we're not doing this, and it's not the right way. And if you want to price regulate, do it properly. If you want to implement the health market inquiry recommendations, do it properly. But one can't play with people in this way. So the reaction from those groups, the whole UAC group, is really strong. Heather, I don't know if you've got any other insights.
I don't have any other insights on that. I wanted just to pick up on Tanya's question about what would we do if the regulation was passed, either in this form or in some form. The only way to attack the regulation would be to bring a review, which would allege that the minister's passing of the regulation was unlawful. Effectively, it would be like a PAJA type review that says outside of the scope of the minister's powers, not exercised for the purposes for which the power was granted, etc. And then, that review would have to wind its way through the court and eventually get a decision that says the minister is or is not allowed to do this. It's quite interesting because I think under the Competition Act, there's a sort of dual power between the tribunal and the Competition Tribunal and the High Court. You'd obviously have to decide which of those you think you're better off in. But either of them, it is a very kind of long process. So I suppose the best you could hope for by bringing such a review is, well, first you hope that you'll be successful at the end at least. But it would also be very risky for any funders to get into this MLNF and start reaching agreements on tariffs, and then the exemption gets set aside years down the line, and now you've been price fixing for 3 years. So I think it would spook funders and any HCPs into saying, well, we can't participate in this thing until we know whether it's legal or not.
Thank you for that, Heather.
And there's, there's a big unknown here, I guess. And, when you're thinking about the timing for bringing that review, obviously a PASA review has to be lodged within 180 days of the administrative action that you're wanting to set aside. But the reality is that setting up this thing, nominating the people that are going to go and sit there and getting them going on doing the work of reaching these agreements will take months, if not years. So it's not like you can wait and see if the outcome is bad for you and then bring your review. You've almost got to take a view in principle. Do we think this is lawful or not? Do we think it's allowed under the minister's powers, the DTRC minister's powers under the Competition Act, and bring that case and ventilate that question first? It's not really dependent on the effects of the bargaining. It's really a question of whether the bargaining, allowing the bargaining to happen under the Competition Act is a proper use of the minister's powers.
Bulelwa?
Thank you, Nomthi. To Elsabe and Heather, who do you believe is going to be mostly affected by these regulations? And I know you probably have answered this question differently. In the past, it was the healthcare professionals that approached the Competition Commission to be exempted to make certain decisions on their own. In the past, it was BHF on behalf of medical insurances, and we've always put our stance forward in terms of we don't believe that any of the above, I think HASA also did, can do it on their own. And here we are from a medtech space. If these regulations are going to go ahead as they are, do we stand a chance wherein that will be part of this team that will make decisions? Obviously, when I say stand a chance, I mean through representation, not as us maybe will also be conflicted. But I mean, if it also sounds very difficult that decisions can be made and they involve us, but we won't be part of them. So I think that's where my question is.
Willie, it's, Alex did a paper on this, and it is on the UAC website, that basically says it's unworkable. Because for your company, how are you going to, your competitors can't look at your information that you put before them. If you've got a health technology assessment from wherever in the world, and now it gets part of this negotiation process on determining what the fees are that radiologists could charge when using your machines or whatever. I mean, this just, it's inconceivable that it can work. So even if you are there, or even if you do have representation, how on earth are you going to mandate your competitor to negotiate on your behalf? I mean, it's just crazy. I can't see how it could be workable, practical. So even if we did have representation there, how on earth would it work? Or if we then say you go and you yourself are there, and next time somebody else is there, but you have all the medical schemes on the other side. It's not a one-on-one thing. I simply can't see how it is workable. It just seems unworkable. Heather, I don't know if you've got ideas.
Through an independent consultant that happens to know our market, which is still even going to be very difficult because that person won't be having a true picture.
How independent are you? If I know all your ins and outs, I'm not really independent. Then I know all your ins and outs.
So you know, there's a lot of writing internationally about what the lawyers term ex ante regulation, like price regulation, for example, and what are the criteria that should be in place if you decide you have to regulate prices, which I must tell you is always a last resort, because in general, you put your faith in competition in markets to find the optimal price level. That's how it's supposed to work. So, you know, that's how it works in retailing or car sales or any product you can think of virtually. The fact that the competitors are out there slugging it out, they're offering discounts, they're offering incentives, you know, there's a balancing that goes on between what the customers want to buy, what the suppliers are willing to sell, what the customers are willing to pay, what the suppliers are willing to give, that eventually sets a price, which is a competitive price. If you decide that mechanism, the market mechanism, is not working, now you want to start dictating what the prices are. You have to, as Elsevier says, have a proper independent regulator that can actually do that calculation. And I must tell you, the examples we've got of this in South Africa are not good. There's been a fight going on in the High Court about the regulation of the gas price, which is a fight that Sasol's involved in, I think for more than 10 years, on the basis that NERSA got it wrong. There are examples in the telecom industry where NERSA has determined that the mobile phone companies will transfer calls between networks at set fixed prices, which will decline over time. There was also a whole raft of litigation about that kind of price setting. And that's in a world where you actually do have an independent regulator and you have a proper act of parliament that says there will be price fixing by the regulator, and this is the criteria the regulator will apply when they set the price. And this is the process that they'll adopt. Everybody who's got an interest in this tariff or this code has a chance to make an input, and then at the end the decision is made and it's binding on everybody. You know, those are well established international principles for price regulation, which you'd expect us, if we now in the business of regulating prices, but not just for one product, right, across a whole entire healthcare services sector. You know, there's no regulator, not clear what the criteria are. There's mention of price cost, but it's not clear why that should be the only consideration. And that's not set in an act of parliament. It's just in a regulation that the DTIC minister has dreamed up. It's a very unsatisfactory way of actually undertaking a fundamental change in the healthcare sector, which is that we are no longer going to allow competition to do its work. There's going to be a decision on pricing made. But in this case, as we both said, by a very small group of people. And the other big unknown is whether anyone will actually participate in this thing, even if it does come into effect. So there's a big risk, you know, even if some of the funders put their hand up and go and say to the minister, I would like to be around the table, please pick me, you know, that they would have to be quite sure that whatever tariff decisions come out of the TGB, if you can't reach agreement in the MLNF, they'd have to be sure that those would be okay. Otherwise, they could end up having prices set which they don't think are in their interests for all sorts of services. So, you know, it's quite a big risk to take. I'm not sure which funders would go for this, even if it is put into place. So I guess maybe that's the best case scenario world, which is an alternative to our one. Either we set aside the regulation, well, we convince the minister it's a bad idea, we go to court to set it aside, or they implement it and actually no one puts their hand up to participate, because that would mean nothing happens. That they can't compel people to go and agree on tariffs. They can't frog march them into the room because there's this regulation that says they may. It doesn't say they must. So it's a big unknown. But I'm sorry, I've seriously eaten into Elsevier's time now on everything else. So I apologize for that.
No, it was quite fruitful and informative, and really appreciate it. Please don't stop with your questions when they come and when they arise. Any uncertainties, please send them to me by email so I can direct them through to Elsa and Heather. Much appreciated, Heather, and of course Elsa as well. This was quite comprehensive and thought-provoking as well. So yeah, while we're here, Elsa, do you want to lead us into the updates? How are the NHI regulations looking?
Right. I think I sent you my slides, if you can project them. Great. Next one. Okay. So this is just an update on what has happened. You know, there's 4 court cases that's been filed. The 4th one was in February, the HASA one. And then if we go to the next slide is the one that was filed yesterday, which is the Medical Association one. Of all 4, if we quickly go back to the other 2, the other slide, there's 2 that I've marked with a little star. Those were actually already in court. So the BHF and the SAPPF case on the president should never have signed the NHI bill into law. That was heard. The ruling is expected only in 6 months' time. Once we have a ruling on that, and this is only as to in which courts they should be. So BHF and SAPPF said we can go to the High Court. The presidency said, no, because I'm the president, we must go straight to the Constitutional Court. So we'll see how that plays out. And then there's only the substantive arguments on whether the president should have signed. And only then will, after that, the second part of the SAPPF case be heard. The Solidarity case is we've got Solidarity's case, we've got the minister's answer, and now Solidarity has a right to reply. And that they'll only file in July. So these cases don't go fast, and if this is a blueprint for what could happen with these block exemptions, I think we're in for a similar thing. So on the next slide then is the SAMA's case that was filed. It is different to the other cases because it's the first case that includes the public sector and makes mention of how the public sector will be affected, and a lot of emphasis on patients. And then also providers in terms of if you know, we often hear in the NHI discussions this debate, oh, there's so many empty hospital beds. But a bed can't treat a patient. You need a doctor to treat a patient. You need a nurse to treat a patient. So the human resources challenges is important there. They've done great research through VIR, Tini Stander's organization, to show the capacity constraints and what would be expected of private sector doctors if they have to serve the whole population, if they contracted into the NHI, and it assumes they kind of all decide to contract in. And with some of the specialties, it's scary, like with the anaesthetists, they need to increase their capacity with 400%. Now that means you need to work 4 times the hours that you currently work. So yeah, and then the issue of their medico-legal insurance, they're bound by the NHI Act, but the NHI won't cover them for anything that goes wrong. And then they're the only people that kind of touch on procurement and also talk about the unknowns in the procurement system and the implications for providers. So of all the submissions, HASA also touch on it a bit, but I think this, so we'll see how people are actually addressing the issues. That's basically actually your and the PTG's issues in terms of procurement. Next slide. So this is in the SAMA submission to court. They do say we're not opposed to universal health coverage at all, and that we are just saying that we need to go about that differently. And SAMA's international expert, Professor Skalkens from the University of Leuven, he explains how in all countries they start with what they have and they identify gaps and they plug the gaps. They don't say, you know, we're going to take the province's money, reallocate the functions, and put it all in like in one shot big thing. So it's much more measured, and coverage is expanded for certain groups. The NHI Act just says there's 9 definitions of what healthcare could be under the NHI. So this is a positive development. This is also, it already includes the BHF and Universal Health, you know, the administration company that some of you may know. So it is a really nice thing. You'll see there's a comparison between what this proposal is and what is in the NHI Act. So it's quite a positive development, and SAMA leveraged on that in its submission to say they're not opposed to changing the system. We all know we must change the system, but we cannot do these vague things and just leave it up to the minister in the end to decide what is in the formulary and what isn't in the formulary. Next slide. And that then brings us to the implementation, but the draft regs. So the draft regulations is to bring actually about more than half of the sections of the NHI Act into effect. And the whole idea is that this will be finalized. The board will be appointed by this financial year end. So exactly in a year's time, we would have an NHI board and committees, and they could then start working. The CEO could then start working. And this has been done for that phase 1 of the NHI that says we need to start contracting. You need to have a legal entity that could contract. Overall, the regulations have got details in that you normally don't have in regulations, such as an interview questionnaire and a board self-assessment tool. So it's a bit weird. And the other point is it creates a lot of structures, but in the end, it is actually the Minister of Health that will determine things. So, and that's again that problem that was raised, and it's also in Hasa's papers, the issue of plenary powers, powers that Parliament should have exercised, but they're farming out to the minister, is problematic. And you'll see that in these regulations as well. Next slide. So the board and CEO, the minister will call for nominations. One could only be nominated if 5 different entities or persons support you. It doesn't actually say how that would work in practical terms, because normally you'll have a nomination form with 5 signatures on, but this seems to say you need 5 different people to nominate you independently. Then the DG establishes a committee. They will shortlist people. There's a panel chaired by a judge that will interview and recommend. The minister will from that submit names to cabinet, and cabinet will then approve. So you see the minister has got a deciding voice as to what is submitted to cabinet. The minister appoints the chair of that board, appoints the vice chair, appoints the CEO, and appoints 2 of the 3 advisory committees. It's not clear what will happen with the 3rd advisory committee. There's the Benefits Advisory Committee and the Benefits Pricing Committee. Now, the Benefits Advisory Committee has got powers in the NHI Act. It says what they must do. The Benefits Pricing Committee has got no powers in the Act. And then what these regulations do is it says that the minister will describe the roles, tasks, and responsibilities of these committees, which is where that plenary power thing comes in. You want Parliament to say, what must these committees do? It must be in the NHI Act. You can't farm it out. And now the regulations, again, don't clarify it. They farm it further out. And it becomes the absolute discretion of the Minister of Health as to what these people's roles, tasks, and responsibilities would be. So it would be similar to, for example, if we think in the NHLS structure that the diagnostic people will know better, is to say that any of those substructures, they can't do what they subject to what the minister tells them to do. So the NIH or any of these bodies, it's a bit weird. It's not how things normally work. So, and it is part of the problem that we've had with a lot of state-owned entity is ministerial interference in operational things. So this is unfortunately now also in the draft regs. Next slide. I've copied and pasted for you. There's a specific provision on procurement in these regs, and it basically says that there would be cooperation between the board and any other entity relating to strategic purchasing of health services, medicines, health goods, and health-related products. So we've in the past spoken about that conflicting definitions between health products, health goods, health-related products, and medicines. But this basically says that once the board is there, the board would engage with, for example, the Medicines Pricing Committee, or with the HTA body, or with this multilateral negotiation forum, or with whoever. So it's clear that there's already in these regulations kind of a power given to the NHI board that gives us a glimpse as to what people would like to focus on. So there's a direct mention of health products here, but also health supplies, and this facilitates. So if you look at the bigger picture with these block exemptions saying, and let's negotiate there, and the deadline for phase 1, and this body contracting. For them to be contracting, they must be able to liaise with all of these other entities in order to reach a decision on contracting before March, or by the end of March 2027. So it all hangs together. I just don't think it's the right things that are happening from a legal perspective. Next slide. That's the end of it. So that barcode, that QR code, just is if you want to get our WhatsApp updates. I think Sarah and a few other people are on it, so that you can scan it if you want to get those. I promise we won't spam you.
I definitely am part of it, so I agree. You don't spam. It's only good, relevant information, short and in bite. And what is it? Is it biteable sizes? What is it? Yeah. So no, thank you very much for that, LCB. I think it was quite informative and a quite great high level for us to be able to just get a view what's been the evolving landscape. Give it a beat or two to see if there's any questions. I don't see any hands raised. Let's check the Q&A session. I don't see any comments. Okay, there's Sarah. Sarah, go for it.
Thanks, Nomti, and thanks for unmuting me. Thanks, Elzeby and Heather. That was really useful. Just a quick question about commenting on these NHI regs and the fact that it does state that they want nominations for the 2 committees. Should we as an industry be consolidating the nominations that we submit? What is your sense around the next steps for this? Thanks.
Are you talking about the NHI draft regs or the block exemption?
No, the NHI draft regs. Yeah, we still have time, but I would just like your insight. Thanks.
Yeah, no, I wouldn't. We are not at the stage we will submit nominations. We just commenting on whether those structures are good structures. Will it protect the money of the NHI fund? Will it protect us against political interference, blah, 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 all the things that we've seen gone wrong in statutory bodies. So that's where we are. We're not at the stage where we will nominate. We're at the stage where we're commenting on whether there should actually be nominations that's supported by 5 nominations or something like that. So we're at that stage. If the view is that this would be, it would be a stupid requirement to have a person being nominated by 5 different entities, or if we think it's vague, Must we have 5 signatures on one nomination form, or does it mean we must have 5 nomination forms? Those are the things that we're now raising. So we're not at the stage where we nominate at all.
Super. I hope that clarifies, Sarah. Perfect. Okay. All right. Yeah, I don't see any other questions. Elsa B, thank you again. You did a sterling job.
Good. Thanks so much.
Thank you so much. I think, yes. And then our final speaker for today is Avanti Governor Bester. Avanti is the Associate Director of Regulatory and Quality at Alcon Laboratories. She oversees the medical devices and pharmaceuticals component. She is a registered pharmacist with a master's in health economics and pharma economics. She has extensive experience across South Africa's public and private healthcare sectors, as well as in Singapore. She serves on the SAMED board, is past chair and vice chairperson, and currently deputy chair of the Health Policy Subcommittee. So we are definitely in good hands. Avanti, if you don't mind to just take us through the SAMED's NHI position paper. This is exciting.
Nampi, I just want to check that you can hear me.
Loud and clear.
Okay, thank you very much. Good afternoon, everyone, and please excuse my camera not being on.
Your signal's just a little bit, it comes and goes. Don't know if it's a network issue, if you could just move around a little bit, maybe. Okay, and then test. We can't hear anything at the moment. Still can't hear.
Sorry, Namti, please confirm that I'm back on.
Now you're back on, yes.
Sorry, so I was saying that I was on vacation, so I think that's one of the unfortunate realities of being not in an office space. Okay, so good afternoon, everyone, and this last session is just to remind our members, and for those of you who haven't seen it, a brief overview on our position paper. I think before I start, just to mention that the SAMED position paper is not a document that will remain as is. As you can see, things are moving quite quickly, and this document is a live document, and it may be our position now in principle, but there are obviously things that we could add on as things change along the way. I think just as a starting point, and I need to see my screen, thank you. As we would have seen this morning with SAMA, we have a very similar sort of introduction that SAMED itself supports the principles and the objectives of universal healthcare. And that deals with inequalities, recognizing a well-formulated NHI, addressing both the private and public sector challenges, and that we're looking towards a milestone approach, and that we would need implementation that is adequate to impact patient and outcomes that are positive for us and the patient population. You can change slides, please. Thanks, Namti. So what we've done is, and as I said, this is a summary, we've come up with 10 key positions on NHI. Each of these positions are very well documented, researched, and put quite clearly in our position paper. I'll go through them individually. The position paper itself is available, and we will discuss it with members throughout the year. Our first position talks to the support of universal healthcare. And I think I've spoken to this already, is that SAMED in principle believes that universal healthcare is the best way for South Africa to move forward. We then go into our metric procurement framework. Here, a lot of detail talks to our own experiences as companies and the industry in terms of how we feel efficient procurement in medtech can work in both sectors. We go into detail about an independent HTA. We then talk about value-based procurement, leading into timely and accurate payments. We also support choice and multi-players within the medtech industry. We have offered alternative financing models, and as mentioned previously, that we believe a milestone-based implementation will best work for universal healthcare system. We want a consultative and inclusive policy formation, and we need a strong governance framework. So just to be clear, the document is quite a long document, but these are the 10 positions that we feel SAMED needs to advocate for. I think it's also important that we realize that SAMED is here to represent medtech as companies, and where we may engage extensively with stakeholders, we do not always align with the stakeholders that we engage with. Currently, we sit on the BUSA Health Pol Committee, as mentioned, and we engage with stakeholders on a daily basis to ensure either that alignment or that our stakeholders are aware of our positions in these 10 key points. Next one, please, Namti. We do make quite clear what medtech is all about. What we found in our consultations is that we need to remind our stakeholders exactly what SAMED is about and what the medtech industry is about. Our difference in pharma, for example, the supply chain, our procurement systems, etc. And we need to make this quite clear when we have our discussions. And we tend to do that at all forums or webinars that we attend. Next one. If we had to put it into sort of 3 key areas or take-home points, is one of the things that we're working on is an independent HTA agency. We do advocate for flexible procurement. And lastly, transparency and consistency in the process. I think one of the biggest discussions we have around NHI is, how is SAMED taking its position forward with our stakeholders? Why are we not taking up, for example, legal action? And where is it that we are engaging to make sure that SAMED is represented? Over the course of the next few months, including the AGM that's coming up, we'll make this very clear to our members as to how we are moving forward. Noting at this time that we are at the table in both government and private sector organizations to make sure that medtech is at the table to discuss what we need to. Namti, I think this might be my last slide. Thanks. I think there were a few comments made prior that certain stakeholders did bring forth legal challenges, etc. We are very focused that both the public and the private sector need a good balance in order to ensure sustainable and efficient universal healthcare system. We do collaborate with government. And as we can see, that a lot is moving ahead in the background, even though in terms of the political space or the media space, there are these things happening out there that seem to show that NHI is perhaps delayed. However, we are very, very aware that these committees and structures that are being created, together with the teams that are within the Ministry of Health, this is happening, and SAMED needs to be at that table to make sure that we can have representation on these committees and that our voice as medtech is heard. And lastly, we do advocate for a functional NHI. And I think that is quite important because as members and companies, we have direct experience with the procurement of our goods and services. And we're hoping to bring this experience to make sure that universal healthcare in this space can be executed successfully. Thank you. And I think just finally, before we go into questions, what will happen for the next few months is that this position paper will be made widely available. We'd like members to scrutinize it. We'd like members to have a look at what we may have missed, those areas that you think we should be concentrating more on. And these will be held in terms of forums through our NHI committee, perhaps some surveys to members at our AGM. We want members to engage with this position paper so that we can make sure that we are representing medtech in its entirety. Thanks, Namti.
Thank you, Avanti. You mentioned that this is definitely a live document and forever evolving. When and how would members engage with this document?
So we wish to do a proper launch of the document at the AGM in a month and a half. Apart from that, we will, as the NHI committee, look at the position paper and reach out to members on each one of the positions that we have. So each one of the 10 that I've mentioned, we do have members who have a lot of experience in each of those areas. And we want to take this experience in terms of what we want to position to the Ministry of Health and to our stakeholders. So just to recap again, launch at the AGM. The committee is working on some surveys and forums that we can engage with members on. And that will help us shape this document in future. Thanks.
Sounds good. Thank you. Amanda?
Thanks, Nomti. Beautiful piece of work, guys. Really lovely. It was interesting, Avanti, at the EPASA meeting this morning, they stopped at just being in support of universal healthcare. So even with Anban and Mark Bletcher in the room, they didn't go any further than that. It was simply a stated support of universal healthcare and then nothing else after that. So they missed a really good opportunity, actually. And then a patient advocate actually stood up and said, you know, it's competition in this industry that is causing problems, so many problems. So actually the patient advocate was all for no competition, if that makes sense, and that healthcare should be much more broad and holistically thinking across the industries, that we tend to silo into very narrow types of product and diseases, and that means a lot of things are missed and not taken care of properly. So very, very interesting to hear the different perspectives, but they certainly lost an opportunity this morning to make a few points beyond just simply being supportive of universal healthcare. And then, of course, it became just about me, myself, and I, and I'm so innovative that I deserve to be paid more. So I don't think it scored very many points with Anban and Mark. Mm-hmm.
Yeah, thanks, Amanda. Really appreciate that. I don't see any other comments or questions, hands raised up. But if you do have any comments as you engage with the document, please feel free. You can direct them through to me. Emails remains the same, communication without the S at samet.org.za. And we will then be able to channel those comments right through to the NHI committee for consideration and be able to have then a document that is inclusive of your comments as well. We have come to the end of our session. Really, thank you so much for your time. I'm hoping that you will then at least have a good, I think it's 7 minutes, about 17 minutes left of the afternoon. So I'm hoping that you'd be able to at least take that and be able to dash home if you are driving in traffic. If not, I do hope that you have a good evening, and thank you so much for availing your time to participate. Have a good afternoon. Bye-bye.